Yeah, so some people are asking question, how did Jerome become a United States citizen? What did immigration know? Because remember, that in 1986 he was arrested and charged with murder in Jamaica in Clarendon by the Maypen police. Character is everything, especially when you ask America for citizenship. People need to understand something very important about United States immigration system. Character matters. Truth matters. And what you put on an immigration application can follow you for the rest of your life. When somebody applies for immigration benefits in the United States, whether permanent residence or eventually American citizenship, the government is not simply asking, where do you live? Yes, welcome to the Jamaica Young Police channel. To our loyal viewers, subscribers and Patreon member. At the channel, we are a group of law-abiding citizens who believe in the rule of law and respect the rights of every citizen, but not the ones who do not subscribe to such behavior. We do believe in and support preemptive strikes because they save lives. This is a logical conclusion because preemptive strikes save lives and prevent the further loss of lives. We are all about saving lives at this channel. We at the channel aid criminals with a passion and do not want them over here. We do not want your views, your subscriptions, your likes or your comments. Please go elsewhere where the red carpet is waiting for you. Over here, we want you to go to prison or the departure lounge at Madden. Moving on to today's video. What is your name? When did you enter the country? They're examining something much deeper. Who are you? Meaning Jerome Cunningham. And when a person reaches the naturalization stage, good moral character becomes a legal requirement. USCIS say applicants for naturalization must establish good moral character under the Immigration and Nationality Act. That is why I say character is everything. Because when the United States government asks you a question on an immigration form, that is not the time to become creative with the truth. It is not the time to say that happened in Jamaica, that happened 30 years ago. Nobody in America knows about it. That record probably disappeared. No. Look at what the current N400 form asks. The naturalization application specifically asks applicants whether they have been arrested, cited, detained, confined, charged with crimes, or otherwise involved with law enforcement. That talk about like Sprague Benz. Yeah. Buju Banton is a convicted drug dealer. Vybz Kartel, same thing. Was acquitted by the court. The instructions expressly address arrests and detentions occurring anywhere in the world and require appropriate documentation concerning the disposition of criminal matters. That word ever is enormously important. It doesn't mean since you came to America. It doesn't mean during the last 5 years. It doesn't mean only tell us what happened in the United States. It means what it says, ever. So, hypothetically, if someone was arrested and charged with murder in Jamaica in 1986 and decades later applied for American citizenship, the existence of that old case could still be something immigration authorities expected the applicant to disclose when answering the applicable questions. And as a man who's from Jamaica and know we were cultured, nurtured, domesticated and socialized, that information would never find itself on paper. The biggest of criminal or crime lords from Jamaica would not put such information, even if they were arrested, charged, convicted, and deported from another country. They're not going to put that. But, and the distinction is critical, being arrested and charged doesn't mean the person committed the crime. A charge could have been dismissed. The accused could have been acquitted. The prosecution could have offered no evidence. The matter could have been discontinued. The person could have been completely exonerated. That is why I refuse to jump from Jerome was allegedly arrested and charged to Jerome lied to immigration. We do not have evidence establishing that. Because people are wondering, him get citizenship and him the charge with murder at Jamaica, and we know him not put it on the form. What you need is the disposition of the Jamaican case and ideally relevant American immigration records. But suppose we're discussing an immigrant, not Jerome Cunningham specifically, and that individual deliberately conceal a serious criminal history from immigration authorities. Now we have an entirely different conversation. A lie can become bigger than this original problem. USCIS states that naturalization may be revoked when citizenship was obtained through concealment of a material fact or willful misrepresentation. Think about that. A person might believe, I got my citizenship, it's finished. Not necessarily. If citizenship was obtained unlawfully because an applicant deliberately concealed a material fact, federal law provides a mechanism for denaturalization. The Immigration and Nationality Act expressly permits proceedings to revoke naturalization that was illegally procured or obtained through concealment of a material fact or willful misrepresentation. And that is not merely ancient law sitting unused in a book. In 2026, both USCIS and the Justice Department publicly announced multiple actions seeking to denaturalize individuals whom the government alleges concealed crimes or lied during their immigration and naturalization proceedings. Those are allegations until adjudicated, but they demonstrate that denaturalization remains an active enforcement mechanism. So imagine spending years building your life. You get your green card, you work, you establish a home, you raise children. Eventually, you stand there proudly and take the oath of allegiance. You receive that certificate of naturalization. You believe that chapter is permanently closed. Then years later, investigators discovered that a material fact was deliberately concealed during the process. Suddenly the question is no longer simply, what did you do 30 years ago? The question becomes, did you tell the United States government the truth when it asks you? That is why honesty at the beginning matters so much. Not every incorrect answer takes away citizenship, and we must be legally responsible here. Some people hear false statement and believe that one incorrect answer automatically means citizenship disappears. That is not the law. The Supreme Court made an important distinction in Muslim Jack versus United States. In the naturalization fraud context considered there, the court rejected the idea that any irrelevant falsehood automatically permits loss of citizenship. There generally must be meaningful connection between the illegality or false statement and the acquisition of citizenship. USCIS similarly describe a material misrepresentation as one involving a fact relevant to eligibility for immigration benefit. So there is a major difference between accidental misstating an insignificant date and deliberately hiding something that could have changed the government's decision. That distinction matter. Lying on the oath creates another character problem. On a concept people should know is false testimony. USCIS states that false testimony can prevent an applicant from establishing good moral character when the person deliberately attempts to deceive the government on an oath to obtain immigration benefit. Think about the significance of that. Citizenship isn't merely about how long somebody has lived in the United States of America. It isn't merely about paying taxes. It isn't merely about passing the civic examination. Congress specifically made good moral character part of the naturalization process. So when someone knowingly lies on the oath to obtain an immigration benefit, the lie itself can become evidence bearing directly on character. And murder is an entirely different category. This brings us back to why this disposition of an alleged murder case would be so important. USCIS states unequivocally that person convicted of murder at any time is permanently barred from establishing the good moral character necessarily for naturalization. Notice the difference. It said convicted, not arrested, not questioned, not accused, not rumored about on the street. Convicted. That is why finding the outcome of the alleged 1986 Jamaican case is essential. If there was no conviction that could fundamentally change the immigration analysis, if there were a conviction that would raise extraordinary, serious questions about how naturalization could legally have occurred, and if somebody knowingly concealed a disqualifying conviction during immigration proceedings, that would raise yet another issue. Whether immigration benefits itself was obtained through material concealment or willful misrepresentation. But we follow the evidence. So the question about Jerome must be asked carefully. The responsible question is not, did Jerome Cunningham lie to immigration? We cannot establish that from information presented available. The responsible questions are, what exactly happened in Jamaica in 1986? Was Jerome Cunningham merely arrested? Was he formally charged? Was the case dismissed? Was he acquitted? Was there a conviction? What did the Jamaican court ultimately decide? When did he enter the United States? When did he become a permanent resident? When was he naturalized? And if his immigration records ever become available, what did he disclose to American immigration authorities? What did he disclose to immigration authorities? Those documents could resolve what speculation cannot, because two principles must coexist. Never convict somebody in the court of public opinion merely because they were arrested. But equally, never underestimate the seriousness of deliberately deceiving the United States government to obtain an immigration benefit. A person may outrun a rumor. A person may move to another country. Decades may pass. Governments may change. Records may sit forgotten inside old files. But if citizenship was obtained by deliberately concealing a material fact, the passage of time does not magically transform the falsehood into truth. And that is why I keep coming back to one simple principle. Character is everything. Your character is what you do when nobody appears to be looking. Your integrity is what you say when telling the truth may hurt you. And when you raise your hand before the United States government and swear that the information you have provided is true, the oath is supposed to mean something. So in Jerome Cunningham's case, I want the documents. I want the Jamaican court records. I want the disposition of that 1986 case. I want to know when he entered America. I want to know when he obtained permanent residence. I want to know when he became an American citizen. And only after the documentary record answers those questions should anybody declare whether something improper happened. Evidence first, conclusion second. Because if we are going to preach character, then our investigation must demonstrate character too. We cannot condemn dishonesty by becoming careless with the truth ourselves. Character is everything, and truth must be the foundation. If Jerome was merely arrested and charged with murder in 1986, but was never convicted, it is entirely possible under US law that he could subsequently obtain permanent residency and ultimately become a naturalized American citizenship. If he were actually convicted of murder, however, his subsequent naturalization would present a much more serious and unusual legal question, because a murder conviction is a permanent statutory bar to good moral character. When a person applies to become a naturalized citizen of the United States, that process is about much more than learning a few questions from the civic examination and standing in a room to take an oath. The United States government is examining eligibility, residence, conduct, honesty, and character. And that is why I keep saying this. Character is everything. For most applicants, naturalization requires that that person first be a lawful permanent resident, generally for at least 5 years or 3 years in certain cases involving marriage to a US citizen, while satisfying continuous residence and physical presence requirements. Applicants generally must also demonstrate basic English ability, knowledge of US history, and government attachment to the principle of the Constitution, and good moral character. There are exceptions and special rules for certain applicants, but good moral character is one of the central requirements of ordinary naturalization. Now pay close attention to this part. When USCIS examines good moral character, it does not simply ask, have you ever been convicted in America? That would be far too narrow. The naturalization process involves extensive background and security checks, and USCIS questions the applicant about their history. USCIS can examine arrest, charges, convictions, and other conduct when determining whether the person qualifies for citizenship. And this is where people can make an enormous mistake. Suppose somebody was living in Jamaica, England, Canada, Trinidad, Haiti, Mexico, or anywhere outside the United States and was arrested by law enforcement. Suppose the person was detained. Suppose the police carried that individual to a station. Suppose he was formally charged with an offense. That event does not magically disappear simply because it happened outside America. and an applicant should never assume. Well, that happened in Jamaica, so USCIS doesn't need to know. That is a dangerous assumption. The naturalization process can require disclosure of criminal and law enforcement encounters occurring outside the United States. What ultimately matters legally may depend on exactly what happened, whether the person was merely detained, arrested, formally charged, prosecuted, acquitted, convicted, or had the case dismissed. Those distinctions are extremely important. An arrest is not a conviction. A charge is not a conviction. Being detained does not automatically mean somebody committed a crime. You can be arrested and innocent, which is true. You can be charged and acquitted, which is true. A prosecutor can withdraw a case for various reasons. A court can dismiss the charges. The evidence can collapse. A witness can recant. The wrong person can be arrested. So disclosure does not automatically mean disqualification. That is precisely why honesty matters. Tell the government what happened and let it determine its legal significance, because sometimes the concealment can become more damaging than the original event. Imagine someone saying, I was arrested 30 years ago, but nothing came of the case, so I am just going to leave it off. That person may believe he's helping himself. Instead, depending upon the circumstances, he may be creating a completely new problem. USCIS distinguishes between an innocent mistake and a willful misrepresentation. For immigration purposes, a misrepresentation generally becomes especially serious when somebody or someone deliberately gives false information about a material fact, meaning something capable of influencing the government's decision. So if somebody forgets an insignificant detail, that is not automatically the same as intentionally deceiving the government. But suppose an applicant knows I was arrested, he knows I was charged, he knows there was a criminal proceeding, and then when the government asks the relevant question, he deliberately says, no, we may be dealing with something entirely different. And there's another layer. At the naturalization interview, the applicant answers questions on the oath. USCIS states that false testimony for purpose of obtaining an immigration benefit can prevent a person from establishing good moral character when that individual deliberately intends to deceive the U.S. government while under oath. Think about how serious that is. The underlying arrest might not have prevented citizenship. The underlying charge might have been dismissed. The individual might even have been acquitted. But if he deliberately lies on the oath about what occurred, because he believed the truth might hurt his application, the lie itself can create another immigration problem. And that is why the smartest approach is disclose accurately, explain completely, produce a disposition. If you were arrested, show what happened afterwards. If the case was dismissed, provide the dismissal. If you were acquitted, provide the acquittal. If prosecutors decline to proceed, document that. If the police release you without charge, explain. Let the record speak. Do not write your own history because you are afraid of how it looks. Because the consequences of intentional concealment can extend beyond merely having a citizenship application denied. Under federal naturalization law, citizenship obtained through concealment of material fact or willful misrepresentation can potentially be revoked through naturalization proceedings. USCIS expressly recognize concealment and willful material misrepresentation as ground for revocation of naturalization. So they are very serious about this. Even if you were just arrested and charged, not convicted, but just being arrested. And that is not theoretical. The Department of Justice continues to file denaturalization cases against people it alleged obtain citizenship unlawfully or conceal material information during the immigration and naturalization process. In 2026 alone, DOJ and USCIS publicly announced multiple such actions. That means receiving your certificate of naturalization does not transform fraud into truth. Getting a United States passport does not erase a material lie that helped procure the citizenship on which that passport depends. 20 years passing does not make a false answer accurate. And in most serious criminal categories, the consequences are even clearer. For example, USCIS states that a person convicted of murder at any time is permanently barred from establishing good moral character for naturalization. A person convicted of murder anytime. Notice what it said: convicted, not arrested, not accused, not charged, convicted. That distinction is essential. So when somebody asks, how could a person who had once been arrested and charged with murder overseas later become an American citizen? The first question should be, what happened to the charge? Was he acquitted? Was it dismissed? Was the case discontinued? Was he convicted? And the second question should be, what did he disclose to the American immigration authorities? Those are two completely different investigations. You cannot look at an arrest alone and conclude that citizenship was fraudulent. But neither should you look at a certificate of naturalization and assume that every underlying fact was necessarily disclosed properly. You investigate, you document, you verify, because character is everything. If the government asks you a question, tell the truth. If something embarrassing happened 30 years ago, tell the truth. If the case was dismissed, tell the truth and provide the disposition. If you were acquitted, tell the truth. If you were wrongly arrested, tell the truth. Because there is something deeply ironic about trying to prove good moral character by concealing the truth. The United States is effectively asking the applicant, can we trust you? What you are telling us? And citizenship is one of the most significant legal relationships a person can establish with this country, the United States of America, or you suffer alone. So my message to anybody going through immigration is simple. Never assume that an old foreign arrest doesn't matter simply because America wasn't involved. Never assume that because 30 or 40 years have passed, nobody can find the record. And never gamble your immigration status or citizenship by intentionally giving an answer you know is false. Because the original incident may have an explanation. The arrest may have resulted in nothing. The charge may have been dismissed. You may have been completely innocent. But once you deliberately misrepresent a material fact to obtain an immigration benefit, you may have created a second problem entirely, one involving your honesty with the United States government itself. That is why the safest principle is also the simplest. Tell the truth, produce a record. Let the law decide the significance, because citizenship is not merely about passing a test. It's about allegiance. It is about responsibility. And yes, it is about character. Whether people like Jerome Cunningham or dislike him is almost beside the point. What stands out to me is the extraordinary loyalty that appears to have surrounded him over the years. Some people associated with Jerome have had their own encounters with the criminal justice system. Some, according to the records and cases we have discussed, have been arrested, prosecuted, and in certain instances convicted of serious offenses. Yet, despite situations where cooperation with law enforcement can sometimes result in consideration at sentences, I have not seen evidence that any of them publicly turn on Jerome or provide information that brought American authorities directly to his door. And that raises a fascinating question. What created that level of loyalty? Was it friendship? Was it fear? Was it respect? Was it a street code? Was it mutual dependence? Or was there something even more personal involved? Because when you're dealing with people from the same communities in Jamaica, these relationships may go far beyond whatever happened in the United States. Jerome may have known their parents, he may have known their brothers and sisters, he may have known where their children live, he may have known their history long before they were ever reach America, and that creates a completely different kind of relationship. I want to be careful here. Knowing someone's family does not prove that anybody threatened that family. We should never make that leap without evidence. But anybody who understands close-knit Jamaican communities knows that relationships can run through generations. Everybody knows somebody. Families overlap, friendships overlaps, rivalry overlap. People remember who helped whom, who grew up with whom, and who knows whose relatives back home. That kind of social bond can produce incredible loyalty without a single threat of being spoken. And there is another possibility: self-preservation. Sometimes people involved in criminal activity do not cooperate because they are saints or because they love somebody so deeply. Sometimes everybody knows something about somebody else. If I expose you, what can you expose about me? You understand? If I start talking about your history, what do you know about mine? That produces what investigation does sometimes describe more generally as a culture of silence or mutual protection. Nobody needs to sign a contract. Everybody understands the consequences of opening the door. And this is where I would challenge my audience. Do not automatically interpret silence as innocence, but equally, do not automatically interpret silence as proof of conspiracy. Silence is evidence of silence. An investigator's job is to determine why. Did these men refuse to cooperate? Were they ever actually asked about Jerome? Did prosecutors offer cooperation agreements? Did investigators even regard Jerome as a target? Did anybody provide information privately that never became public? Those are factual questions. And until we obtain court filings, plea agreements, sentences in memoranda, FBI records, or other reliable documentation, nobody should pretend we already know all the answers. But I will say this: if you establish through records that multiple associates repeatedly went through the criminal justice system in America, served substantial sentences, and nevertheless nobody appears to have implicated Jerome, then the pattern itself deserves explanation, not condemnation, examination. Because loyalty that survives arrest prosecutions, convictions, prison sentences, deportation fears, and decades of pressure is not ordinary. Is not ordinary. Sometimes, some things is holding that structure together. And I want to know what it was. Was Jerome extraordinarily respected? Was there a Jamaican cultural bond that outsiders underestimated? Did these relationships originated with their families back home? Was there mutual protection because everyone had information about everyone else? Or were investigators simply never able to establish a good admissible evidence against Jerome Cunningham personally? Those questions are far more compelling than simply calling everybody criminals and moving on. Because if we are serious about finding the truth, then we have to study the network, the relationships, the incentives, and the silence. And until documents tell us otherwise, the responsible conclusion is not they protected Jerome from the US government. The responsible conclusion is, despite the criminal cases involving some people around him, Jerome appears to have retained remarkable loyalty. The question is why? Why he was able to rely on that kind of loyalty. Have yourself a beautiful day. Jamaica Young Police Channel out.